Who actually owns work once it's done? You might assume it's obvious, but unless the contract is clear, the answer might surprise you, and not in a good way. We're looking at IPR in this video. Now let's get into it. So what is IPR and how does it work in practice? The term denotes many ways to protect creations or other content of value. For example, IPR protection may take the form of a trademark, copyright, patent, or trade secret. Such protection can arise automatically in some cases, and in other cases require you to take some action to secure protection. Patents and trademarks usually require an application or registration to be made, whereas copyrights and trade secrets can arise automatically. IPR typically has some commercial value for the owner. If a third party wants to use it, then they will often need permission from the owner and to pay a fee. Is IPR something that you should care about? The answer really depends on the specifics of your deal. When you enter into a contract, is it possible that either party may create new IPR? Is either party transferring sensitive information that is protected by IPR? If IPR is created or transferred, then should one party make a payment to the other party to be able to use it? If the answer to any of these questions is yes, then it's a clear sign to investigate how to manage IPR in your deal and to introduce appropriate clauses in your contract. Let's look at a practical example together. Great Idea Supplier Limited enters into a contract with Background IPR Trading Limited. They agree to work together to combine suppliers' Great Idea with Trading Limited's IPR and to see what they can jointly create. The result is a new invention with great business potential. What can go right for the parties in this situation? The parties started their conversations by signing a non-disclosure agreement. They discussed what each party would bring to the deal, their target of working together, and how to manage any new IPR that results from their collaboration. They subsequently signed a collaboration agreement that included IPR clauses to address the position they agreed. This advance alignment, combined with appropriate clauses in the contract, significantly reduced the chances of disagreements later. In this case, the parties agreed that Background IPR Trading Limited keeps ownership of its Background IPR. However, Great Idea Supplier Limited owns the new IPR that they created together. In return, Supplier Limited pays Trading Limited a pre-agreed sum as full and final settlement for that transfer of value. Both parties get what they agreed in the contract and are satisfied with the outcome. What could go wrong for the parties? Let's say that they were old friends who had always wanted to work together. They had conversations about the possible outcome of their collaboration, but didn't put anything in writing, thinking that they would remember what's important and that their relationship was good enough to agree on all other matters as they went along. Upon creating something with great commercial potential a year later, they rediscuss who should own it and what each of them can do with it. They both claim that the other person has changed their position from what was agreed verbally and are asking for more than is fair. Given they didn't agree how to deal with IPR in writing, their dispute escalates and the friends fall out. The matter goes to court, which is expensive, stressful, and time-consuming. Let's look at a sample clause and some key considerations now. First, to a definition. IPR means intellectual property rights that are owned or licensed, whether registered or not, and includes inventions, copyright, patents, trademarks, and know-how. And now to the clause, each party retains exclusive ownership to its IPR. A party may only use the IPR of the other party to perform its obligations and for use of the equipment or service, whichever is applicable, in accordance with the agreement. First, let's look at the definition. Does it cover the types of IPR that are relevant to your deal, or does it define more than you need? As a rule of thumb, it's preferable for the definition to be broader than you need than to exclude something that might later become important. Second, the clause explains that either party can only use the other party's IPR in accordance with the agreement. This prompts you to look at how this topic might be addressed elsewhere in the contract. For example, does the customer need to buy a license from the supplier, or pay a regular subscription fee to have continuing use of IPR? Our sample clause continues. any new IPR that may result as a direct consequence of performing the agreement will be owned by or be transferred to the supplier or customer, whichever you agree. In such case, the supplier or customer will pay the other party a sum of, then you insert the relevant value, as full and final compensation. This kind of clause is particularly relevant to research and development agreements, or whenever two parties work together to create something new. It's usually not needed in a simple sale contract where the customer only pays for the product or service and does not contribute anything else to the creation or development of the product or service. To wrap up, make sure to state in your contract who will own any new IPR and any arrangements for licensing and payment obligations. The risk of something going wrong increases when IPR management is not addressed in the contract at the outset. Next, keep all rights to your IPR as your default position unless you're getting something of sufficient value in return. Finally, only grant licenses to your IPR when they're genuinely needed, define them narrowly and price them sensibly. I hope you find this content helpful. If you're ready to speak with an expert or to hire a lawyer, then check out starlitcontracts.com, where we will help you to retain a lawyer or law firm to address your requirements. I look forward to seeing you there.